Hello, my name is Justin Ng, and I'm a legal associate currently working in a PSA firm. In the scenario given, there are two parties involved, namely Mr. Brandon, who is the mortgagor that borrowed money from the Tough Bank, and Mr. Tristan, who represented the Tough Bank as mortgagee, and he just suggested a foreclosure on Mr. Brandon's property because his mortgage had become upside down. There are several issues to be discussed. For example, how likely will the foreclosure action materialize? Can the bank possess Brandon's property or sell the property? We will first start by advising Mr. Brandon as to his rights as a mortgagor in regards to the issue of foreclosure of his property. Foreclosure is undoubtedly a draconian action, and even the Law Commission suggested to abolish the rights of foreclosure in the English law, but the suggestion has yet to come true, so it is still one of the rights of the mortgagee in our current law. Generally, the remedy of foreclosure will only have effect when the mortgagor failed to keep up with the mortgage repayment. This was affirmed in the case of Williams and Morgan. Since Mr. Brandon admitted that the 3 jobs he took were not sufficient to pay for his mortgage, the rights to foreclose his property will arise as soon as the default on payments occur. Following a successful foreclosure, Mr. Brandon's equity of redemption will be extinguished pursuant to Section 88 and Section 89 of the Law of Property 1925. At this point, we can see that the rights of foreclosure often operate at the detriment of the mortgagors and sometimes through no fault from them. Especially during this pandemic, many mortgagors' cash flow were affected by the enormous effect of the COVID-19 and the lockdown measure imposed by the government. However, it is noteworthy that the English law today always wanted to confer an appropriate balance between protecting the interests of the bank and the borrowers. For example, the common law precedents show that to materialize a foreclosure, the mortgagee must in the first step to obtain a court order. This will allow the court to make a nisi order and effectively extend the deadline of repayment for the mortgage property. In layman terms, the mortgagors will gain an extended fixed period of time to pay off the outstanding amount that he owed and therefore to prevent the foreclosure from becoming obsolete. Applying to Mr. Brandon's situation, he will be advised on the court's practice, which usually extend the period for 6 months. So with the 6 months time, Brandon will have a better chance to earn enough money compared to merely 90 days provided by Mr. Tristan. Moreover, the court could also exercise its power conferred under Section 91 Clause 2 of the LPA 1925 to order a sale in lieu of a foreclosure. As in Park's case, the court has a wide and unfettered discretion under Section 91 to order a sale. This will protect the interests of the borrowers, especially in the circumstances where the value of the mortgage property is noticeably greater than the mortgage debt. Following such a sale in lieu of foreclosure, the mortgagor may receive the surplus funds by virtue of the Section 105 of the LPA 1925. This is more desirable to the mortgagor and in line with the fundamental principle of once a mortgage, always a mortgage, because mortgage is not tool for the mortgagee to earn a windfall profits. And this was confirmed in the case of Halifax Buildings against Thomas. On the other hand, when the mortgage becomes upside down as in Mr. Brandon's situation, the court also has discretion to order sale in lieu of foreclosure. This is to protect the interests of the bank because if the Tough Bank insists on foreclosing the property, then their right to sue Mr. Brandon personally for shortfall debt may be extinguished together with the mortgage. The bank will inevitably lose money since Mr. Brandon's mortgage was in negative equity. So foreclosing the mortgage property in that situation is not necessarily beneficial to the bank, and in the long run, this could probably affect the whole macroeconomics as the bank has no choice but to increase the interest rate to cope with the losses arising from the mortgage debt. Today, due to the existence of Section 91 and also due to mortgagee enjoying cumulative remedies, foreclosure is rarely used and is almost unheard of today. This is true, as we can see in this chart. Even before the outbreak of COVID-19, there were many mortgages overdue, but the foreclosure rate was relatively low in the UK compared to the foreclosure rate in the US. This is because the English law protected the interests of the bank by imposing a full recourse policy to prohibit strategic default that allowed the borrowers to deliberately stop making repayments when their mortgage became upside down. Hence, under English law today, on one hand, we can see the court will be merciful to protect the vulnerable mortgagors and thus less likely to allow foreclosure action. On the other hand, they will not be unreasonably lenient to the mortgagors too. If the mortgagors exploited or wasted the chances given by the court, then the court will allow the mortgagee to sell the property or in certain circumstances foreclose the property. I submit that until here, the current law in the UK achieved an appropriate balance between protecting the interests of the borrowers and the bank. Moving on to the next part, There are circumstances in which the current law fails to maintain an appropriate balance between protecting the interests of the borrowers and the bank. Before that, let's look at what happened to me right before last year's Christmas.
Hey, you, give me your money. Sorry, I don't want to do this, but I need money to pay my loan. I will be homeless starting tomorrow because the bank is going to kick me out from my house. The lockdown measure makes me find no way to pay my loan. Whoa, wait a minute. According to guidance proposed by the Financial Conduct Authority in November, all the firms or banks were not allowed to enforce repossession proceedings on residential property until 31st January 2021. The FCA is likely to further extend the expiration of this guidance due to the worsening coronavirus situation. So relax, bro. Please put down your gun. Your house is safe.
Clearly, as of today, this guidance has expired and is not applicable to Mr. Brandon's situation anymore. The Tough Bank is allowed to seek possession order from the court to evict Mr. Brandon from his property unless the FCA decides to reactivate such guidance again. So Brandon still needs to be advised as to whether the Tough Bank can exercise the right to take possession of his property. The answer is yes. The mortgagee still has the right to take possession of his property, and most of the time, a mortgagee would like to possess the property before putting the property on the market for sale. This is because vacant possession is more likely to get a higher purchase price, and thus the mortgagee will be more likely to recover the loan in full. In formats against the Ali Marshall case, the court confirmed that the mortgagee's power to possess is as of right, and the right arises as soon as the mortgage is made or before the ink is dried on the mortgage. Similarly, the mortgagee is not necessarily to seek for a possession order through the court, even when the property subject to possession is a dwelling house. This right to possession is arguably the most effective way for the mortgagee to realize its security whenever there was a default by the mortgagor. It is important to note that the bank could only possess Brandon's property in peace without threat or force. Otherwise, the Tough Bank may be subject to the offence under Section 5 and Section 6 of the Criminal Law Act 1977. At this juncture, I would say that the current law, by allowing possession as of right, actually protects only the interests of the bank. Of course, many would say that this is how security works, even if it may render the borrowers homeless. If a lender could not realize the security easily whenever there is a default, then no one is willing to lend the money anymore. Nonetheless, in reality, the mortgagee will make an application to the court to recover possession of land, as it was rather quick and effective. When the mortgagee seeks the order for possession through court, the Section 36 of the Administration of Justice Act 1970 and reads together with the Section 8 of the Administration of Justice Act 1973 will be triggered to protect the owner of a dwelling house. This could be applied to Brandon by assuming his property was actually a residential house, since he clearly works as a physics teacher and not as a businessman who owns a commercial property. So the Section 36 and Section 8 are very useful responses for him by allowing the court to adjourn or postpone the possession order for a fixed and reasonable period of time. Prior to Norgan's case, we can see the court will generally adjourn the possession for an automatic 2 years. However, following Norgan's case, the court realized that Section 36 and Section 8 did not lay down any time limit for the adjournment and thus allowed adjournment for 13 years in Norgan's case. This decision actually makes the law tend to protect only the interests of the borrowers, because the bank not only has to wait for a long time before taking possession. Going more extremely, the adjournment order is possible to be granted again and again, since both of these statutory reliefs have no limit about the number of adjournment permissible. Applying this to Brandon's situation, he is likely to postpone the possession order of his house, provided that he had evidence to persuade the court to believe him that he actually has a good prospect to repay the loan. The court will take into consideration many aspects in deciding whether to grant the adjournment, such as taking one of these aspects for an example, the court will determine the reason for the devaluation of his house. It might be due to the worsening COVID-19 situation. It is highly likely that the appraisal figures of his house will rise when the situation turns better, especially following the global inflation which is happening now. By that time, he no longer needs to pay more expensive debt. He and his wife's current free job would suffice the repayment. Also, having seen that Brandon was still in need to pay for his daughter's medical bill, I think the court is less likely to be cruel to him and will be very likely exercise the court discretion under Section 36 and Section 8 to suspend the possession. Ultimately, here we come to the issue of whether the bank could exercise the right of sale. According to Section 101, the statutory power of the mortgagee to sell the property arose when three requirements were satisfied. Firstly, the mortgage must be by deed. Secondly, the mortgage debt must be due. And lastly, the mortgage deed does not exclude the power of sale. Since Brandon borrowed money from the Taft Bank, which is considered to be a proper lender institution, I will assume that the bank would make sure their mortgage was in deed form. In fact, Section 33 of the LRA 2002 and also Section 52 of the LPA also make it clear that the mortgage nowadays must be in deed form to preserve its legal status. For the second requirement, there was no mention that his debt was already due in the video. However, since Mr. Brandon admitted that his income was not sufficient to pay for the debt, I would say that the debt is going to be due soon anyway because Mr. Brandon is not going to afford the payment. So this second requirement will be fulfilled very soon. In 20th century banking against your concern, the court confirmed that the power of sale arose when one installment is in arrears. For the third requirement mentioned, since the fact is silent on whether the deed excluded the rights to sell, but it is less likely that the bank will expressly exclude such a right, because the exclusion clearly not beneficial to the bank. Following this, the Taft Bank statutory power arose, but the bank still needed to wait until the right to sell become exercisable by virtue of Section 103 of the LPA 1925. These are what is provided under Section 103. Since the fact is not clear, I will assume that the reason why Brandon appeared in the bank was because he received a notice requiring payment of the whole of the mortgage money by the bank, and thus he went to the bank to seek an explanation. If 3 months passed after he received the notice, then one of the requirements was satisfied, and thus the bank's right to sell become exercisable. From the above, we can see the current law does not allow the mortgagee to exercise the power of sale at his absolute discretion. A mortgagee must comply with the requirement of the LPA as mentioned above and cannot exercise such right until and unless requirement and circumstances as provided under Section 101 and Section 103 are met. This shows how the law provides the right to sell to the mortgagee, but at the same time protect the interests of the mortgagor. Actually, I already agree that this area of law pertaining to the right to sell confers an appropriate balance since I first learned about Section 91 Clause 2 back in the days when I was still in law school.
Student, please highlight the wording of any person interested under this provision. This would mean that anyone could request an order for sale from the court, including the borrower himself.
Sir, why the borrower wanted to request for a sale? He will become homeless.
Good question. This is because if his property had a greater value than his mortgage debt, then a sale will crystallize the mortgage's immediate liability. He may also gain some money in return because the proceeds of sale will firstly be used to pay for the cost of sale, then the mortgage debt, and lastly the surplus will go back to the mortgagor. Similarly, if the value of the property falls in negative equity, the mortgagor will want to sell the property if he does not afford to pay the installment arrears. This is to prevent the arrears accumulated to the principal of the debt and makes the total cost of the home loan become eventually more expensive.
Other than that, the current law confers appropriate balance in the sense that the law recognizes that the mortgagee is not a trustee of the power of sale for the mortgagor. The mortgagee can always give preference to his own interest in deciding the timing to sell, and he has no duty to take those steps that an owner might take in selling the property. For example, sell certain fixtures separately in the hope of raising more money, or wait for a speculative increase in the value of your property. Applying this to Brandon, perhaps his property value dropped due to the COVID-19, but his mortgagee need not to wait until the COVID-19 situation gets better. If the mortgagee is entitled to sell now, then the mortgagee can sell now. On the other hand, the law also protects the interest of the mortgagor in the sense that the mortgagee owns a duty of care to ensure that the property was sold at the best price reasonably obtainable or sold at the true market value. For example, in Baishan against Black, the mortgagee failed to put the property up for auction. Then, the mortgagee would need to pay a compensation to the mortgagor. Similarly, in Philbin against Davis, the mortgagee exercised the power of sale to sell the property to himself. In such a situation, the court held that the selling price is not likely to be regarded as the best price reasonably obtainable. Of course, there were also loopholes under this right to sell. Pursuant to Section 2 and Section 101 of the LPA 1925, a mortgagee can actually sell the land without a prior possession to take place. In Clark's case, we can see that the mortgagee successfully sold the property to a new purchaser and the mortgagors become trespassers in their own home. This is arguably a shortcut to sidestep the protection given to mortgagors of dwelling house, because in such a situation, the Section 36 and Section 8 of AJA was inapplicable due to the fact that the mortgagee did not request any court order. In addition, putting a property up for auction is the most common way to obtain the best reasonable price. However, there is still a risk that the selling price obtained in an auction will be very low. So I would advise Brandon to find a purchaser himself and bring that evidence through court proceedings to show the court that he had a valid ground to suspend the sale by the mortgagee. This will ensure that he will get a satisfied selling price for his property even though the sale proceeds may not be enough to discharge his debt. In conclusion, Brandon should not be too worried pertaining to the foreclosure. I believe the court is ready to give him more chances, especially during this pandemic. If the court was not to give him some forbearances, mindful that he is still employed during this pandemic, then I can't imagine how the court will treat those who default on their mortgages, having trouble refinancing, while at the same time unemployed in this tough time. I submit that the law pertaining to foreclosure and sale achieve a balance in protecting the interests of the borrower and the bank, but not for the right to take possession. When the mortgagee seeks a possession order through court, the court seems to only protect the interests of the borrower. But when the mortgagee possesses as of right, then the result will be severe disadvantages against the borrower. Thank you.